Hi, good evening. Today is October 14th, 2025. I'm going to be holding this because it's so the sound is better. So today is October 18th, 2025, and it's about 8:40 p.m. U.S. Central Time. My name is Reynaldo J. Aguiar Marcano, and I'm recording this from my home located at the 26714 Valleyside Drive, Katy, Texas, 77494. And today, I'm going to talk about legal topics because I feel like it's a good point to kind of give an update on my strategy. And but this session I'm going to do it a little bit different because I'm using the the output of these videos for other things, and I want to keep it atomic in a way, right? Meaning self-contained. So I want to isolate it both from technical topics and also from substantive matters. And I'll give a little bit of more detail of why. So I think I'm gonna do it more from an angle of, a legal angle, but from the procedural point of view, right? Because that is the fact, really. It's the procedural, right? That's the weapon. So at this point, through all this process, the substantive matters haven't even been touched, right? It's all about procedure. That's the weapon, the procedural rules. So I want to make it legal, right, in this session about legal topics, but more centered on the procedures than the substantive matters. So that's the game plan. And then I have a bunch of technical updates as well. It's just that I haven't found the time to do a session about those. Super interesting things. But I guess I'll have to prioritize this, right? The legal aspect. Part of the reason is that, and this is kind of a technical reason, right? I can't be talking about specific things on the private channels that I have because they will be looking for those keywords, right? And they may get lucky, right? So my technique is basically, I say things over here that I know will get to the right people. The things that they would be expecting me to say on the private channels, like the keywords, like those keywords, I say them here, right? So they're public anyways, and they will hear them anyways, right? But on the private channel, I never mention words that could be predictable to them, right? Even if I encode them in the ways that I do, but I don't give them any chances, right? Yeah, so yeah, it's tempting to talk about the technical topics, but I want to keep this one, atomic in a way. So self-contained. Atomic is more of a computer science term, from atomic transactions we call them. So yeah, so legal topics, right? So I'll start by saying, right, that although some of these observations are, I would say, highly suggestive, right? I'm not gonna make the leap to make any accusations, right? Like I'm just going to state here observations, like facts, right? Like factual observations, facts that are facts. These things happen, right? And they're recorded in these let's call them government-controlled systems, right? I mean, these are demonstrable things that happen, events that occur, right? I'm not making anything up, right, or interpreting anything. Like I'm just going to talk about facts, right? So the saga started on Friday, October 10th, right? I mean, this section of the saga, right? So, and this is on the record because this was a session that was recorded on Zoom, right? Like they must have a recording. I mean, when I say they, I mean the 387 court, right? They must have a recording of this session, right? Of this hearing. So, what happened was that we get to the hearing, right? Morgan Hagner had sent multiple fraudulent proposed orders, right, that she drafted that did not represent what the judge said. Like she invented and fabricated things and put them in the proposed orders, right, hoping that I would sign them. And of course, I didn't sign them, right? So we get to the hearing where the judge is supposed to sign the orders. And because she did this, I took the proactive steps days before that hearing, many days, more than a week before the hearing, to send my own draft of my own proposed orders, right? Writing and memorializing exactly what the judge said, right? So there were two drafts for that hearing, right? Morgan Hypner's draft, which was 36 pages because she invented a bunch of things, and my draft, which was 1.5 pages, because that's what the judge said. The verbal rendition lasted, I don't know, 10 minutes, right? So we get to the hearing, right? Of course, I object because, first of all, she didn't give me proper notice. And she sent notice on the 2nd with a fraudulent draft to which I objected. Then she modified the draft and she sent another draft on October 7th, giving me less than 3 business days. So right there, that draft was already without proper notice. And then she modified it again and sent another draft on October 9th, the day before the hearing, right? And that was the draft that was up for consideration in front of this court on October 10th. So that draft that she was proposing didn't have proper notice. She had sent a notice on the 2nd, but there was a different draft. And for these things, like the notice in question is the notice for the document that the judge is going to sign. She cannot give me notice for a document on the 2nd and then present a different document on the 10th that she sent on the 9th. The notice clock resets every time she changes the draft, right? So I object, and the judge refuses to rule on my objection. Like he doesn't say sustain or deny, right, or overrule. Meaning he ignored the objection, right? And that is important because that avoids the objection getting into the record. And then he proceeded to ask me what was the issue I had with the orders, right? So he was asking about the substantive matter, which is a violation of the process. Like he had to rule on the objection first. Anyhow, so there's, and of course, if I go into details of the substantive matter, which I'm going to avoid to do in this session to keep it procedural, because obviously the weapon is the procedure code, right? The weapon that they use, right, against the targets. So, but yeah, I answered to the judge the question, and I told him like 3 or 4 things that, on the substantive matter of the issue, to get it on the record, right? And then he said, well, obviously, this order is heavily contested, so I want you back in person here next week. And then there was a short discussion about when exactly. They proposed Monday, then Tuesday, back and forth. And then at the end, they settled for Thursday, which is in 2 days from now, on the 16th. And they set the time for 9 a.m. So that's how it ended, right? So because of that, I went and filed, or I'm pretty amended because I already filed it, but I amended a petition I had made to the appellate court for a writ of mandamus, which is an extraordinary measure for cases like this, right? Because in this case, right, the period of the orders that the judge rendered verbally on September 11th was for 60 days. And by the 10th, it had been already a month, right, for an order that would last 60 days, so 2 months. So basically 50% of the time of the orders had not been signed. Right? And this is a violation of the process because as long as the orders are not signed, I cannot appeal them. Right? So they're basically creating a verbal order that is unappealable, right, to keep me in this state. violating due process, because I should have the right to appeal whatever order they issue, right? It's a constitutional right. So, I raised the issue of the more delays, because the order is, but the judge stopped me. He didn't let me even talk, right? He didn't even let me object. So that's another violation of the process, right? And again, I'm talking about procedure, right? This is procedural. Like if I'm objecting, like he should at least hear the objection. He shut me down, right? He stopped me. He prevented me from talking actively, right? He took active steps so I could not talk. And then at some point I asked him, right? Please, may I be heard? I asked to be heard, and that is a right. Any defendant or respondent or litigant has the right to be heard by the court, right? They can then decide and rule on whatever I say, or ask me to shut up, right? But they need to at least hear what I was about to say, and he didn't let me be heard, and that's another violation of the process. So with all these violations, I went and amended my petition for mandamus, right? This was with the first appellate court. Now, that petition I had filed like a week before, right? And I amended it with the new developments. Now, during all this process, I've been filing supplemental exhibits and things like that. And even at some point, I filed even a TRO, a temporary restraining order, an emergency one. And I paid the emergency fee. Like I followed all the procedure, right? And the appellate court did not respond to any. I mean, they responded in the sense that, yes, the document was accepted, filed, right? But they did not rule on any of my motions, anything, right? For a period of over a week, right? And I know appellate courts are, higher courts, so the process is usually slower, I guess. So, I give them the benefit of the doubt. Like, I'm not saying that they acted improperly or anything like that, right? It could be a normal court delay, right? Now, if there's a child involved and there's an allegation of danger to the child, I imagine, right, they should have a process to speed things up, right? But still, they didn't respond. All in all, I think probably something like 11 days. They haven't really responded, right? Maybe a little bit. I have to check the actual dates. So this is where it gets interesting, right? And here I'm going to talk about a little bit about technical. I'm going to make it a little bit technical, but to explain how I'm doing, because it's relevant, right? To show a couple of things about the technology, right? So in the books, I talk about the legal vaccine, and this is a system that I developed to basically test legal arguments, okay, and to generate legal arguments based on structured data. Things like transcripts of these demos, right? Or transcripts of recorded conversations, or emails, or email exchanges with the clerk, or with the like with all this information, this system is able, and with the filings, right? Like with the documents that Morgan Heiner filed and the petitions and the fraudulent orders, all those things get ingested into this pipeline, and the pipeline does semantic analysis on the text to identify entities, and then it does a bunch of technical things that I'm not going to get into, and it's able to derive legal arguments and say, this could have these implications, right? And I can configure the system to act as either side, right? I can configure the system to act on my behalf as if it was my lawyer, for example, right? And it would tell me, well, these are the things that you could do, right? And it would actually, produce legal arguments, right? And I can also configure it as if it was Morgan Heiner, right? To attack my documents, right? So I can produce a draft, and I can attack it with this system, configuring the system as if it was Morgan Heiner, right? To act on behalf of Morgan Heiner, or to help Morgan Heiner, right? And that way, I create this iterative process in which I create a draft, my own system attacks the draft, and produces another document that is basically to try to get my draft dismissed, right? by any means necessary. It could be procedural, could be using procedural arguments, or using substantive arguments about the contents of the document. And then I take that output and I feed it again to the pipeline, but configured as working for me, to attack those arguments and produce counter arguments. And with those, I strengthen the document and I produce a second version, right? A more robust, or right. And this way, I produce this iterative processing. I could keep doing these iterations for 10, 20, 30 iterations, right? And at the end of this process, the arguments get more and more high level and more complicated, right? And the documents get stronger and stronger and stronger, for both parties, right? Until it gets to a point where the iterations are not producing any advancement. Right? When I get to that point, I know that the document for my side is basically unassailable. Right? It's so strong that my own system is not able to derive any new arguments to defeat it. Right? So that's what that's the technology, right? So what I did, right? Of course, weeks ago, right? As I'm doing this, right? In this process of, responding to the 387 and trying to get help from the appellate court. Now, I have to tell you another thing, right? And again, this is just an observation. It's just a fact. This is a fact, right? It's not an accusation or anything. It's just a fact. One of the metrics that I used because in this case, the 387th core has a particularity that it has, right? Is that in terms of the higher cores that have jurisdiction over this 387 court, there's two higher courts that have jurisdictions, meaning that there are appellate courts that could review the decisions made at the 387. One is the 14th court and district court, and the other one is the first district appellate court, right? The name, I may not be pronouncing the name in the right order, but one is the first and the other one is the 14th district. So, and here, the person seeking relief can decide to which one go, right? You can file on the 14th and you can file on the first. And they have an internal system that kind of does a supposedly random round robin that to do basically load balancing among the cases, right? From what I understand. When I say these things, please bear in mind, I'm not a lawyer and I've never practiced law in Texas or in anywhere really. But I imagine, right? If this keeps going, at some point I will apply for the bar. Right? I will have to try to take that exam. But anyhow, at this point, I have no experience or anything, right? So I may have certain details wrong, right? I may not have them correctly. Forgive me if that's the case. I'm just a small guy trying to survive all this, right? So yeah, so the first thing, right? When I saw that is, well, this is a fork in the road. I have to decide which way to go, and the choice is important, obviously, right? Because I know, right, how they work, right? So the first one of I use different metrics to make this choice, but one of the metrics that I derived was how many of the justices and judges in these two district courts were appointed by Governor Greg Abbott. And why this is important is described in the books, okay? And the composition of the two courts is very different. The 14th have 4 judges that were originally appointed by Greg Abbott to those posts or previous posts that they have, right? It doesn't mean that they were appointed to those specific positions, but at some point in their careers, they were appointed to a bench position by Governor Greg Abbott. The 14 have 4 justices or judges in that category. The first has 7 judges that meet that condition. And again, this is a fact. I'm not making any accusations here or anything. Like this is just a fact that is verifiable, right? So of course, I went and filed on the 14th, right? That was the step I took. But the case load balancing system rerouted my case to the first, the one that has 7 justices. And I think the Chief Justice is one of those 7 justices. Somebody with the Justice Adams is his name, right? So got assigned to the first, okay? And I've been submitting my documents to the first, and the clerk accepts the documents. It all seems normal, except that no action has been taken on any of the motions, right? Except for one motion, which was a motion for leave to amend, because I made a mistake on the first document I submitted, and I needed to amend it, and that motion got approved, but that was approved, I think, by the clerk. The clerk approved that motion because it's more of an administrative motion. I think, I'm not sure about this, but it got approved, right? And I amended my document. But after that, all the motions I filed, they were not ruled on, okay? None of them. Which, if I think about it, seems like the same situation that I'm seeing with the 387 court. And again, this is not an accusation, it's just a fact, right? On the 387, I have filed more than 10 motions, and none of them have been ruled on. The only motion that they ruled on was the motion to recuse of July 2nd. That was the only motion. And I believe it's because they're procedurally obligated to rule on that, right? They cannot ignore it. Procedurally, right? They're obligated to address it. But all the other motions have been sitting there for months and no response whatsoever, any of them, right? And in the appellate court, I was seeing the same pattern, right? And remember, this is a set of temporary orders, right, that I'm seeking relief against for the child, not for me, for the child. The person in danger, even in danger here is the child. And no action was taken, right? So, I'll keep this about procedures, right? I'm not gonna talk about the substantive matter of why, because the substantive matter hasn't been even touched, right? It's all procedure. So I run the legal vaccine, right? On the entire scenario, right? Not on the documents, but on the entire scenario, in the collection of documents, right? The legal vaccine says, well, I'm going to paraphrase, right? Because this is the legal vaccine really is a software system, and it has a bunch of parameters, and the output is, it's one of those things that it's meant. I designed the system to be readable by an engineer, right? Like I really understand what it means, but it's not like plain English, right? Like it doesn't. So I'm going to paraphrase what it says, right? I look at the output, right? And what it means is basically this situation is stalling, right? And this is based on multiple things, contextual analysis, entity recognition, analysis of previous cases, and Texas courts. It's a huge corpus of data that this system uses. So if I paraphrase the output, it would be something like, this situation is stalling, and the window is shrinking because the orders are temporary for 60 days. So it's going to get to a point that the orders are going to expire, and the writ of mandamus will become obsolete. Like there's no point in asking for a writ of mandamus if the orders are no longer in effect, right? And this is where something really interesting happened. It's going to be a little bit technical, but I'll try to keep it, the technicality low, right? The technicality level, I'm going to try to keep it low. So one of the things that I did is that I ingested, in this sea of things that I ingest into this pipeline, transcripts of recordings. All my conversations are recorded, like my phone is always recording, right? And Texas is a one-party consent state, meaning it's not illegal to record your own conversations. Or if a party that is the law exactly says that if a party that is a party to a conversation knows that the conversation is being recorded, the recording is legal. It's not illegal to record a conversation where at least one of the parties part of the conversation knows that the conversation is being recorded. And because I'm part of the conversation and I know it's being recorded, then the recording is legal, right? So I ingested into the pipeline, and these are recordings that happen in my home, in the car, like in public spaces, right? Those are the recordings I'm referring to. I'm not talking about anything else. So I ingested all the recordings that I have in conversations with my former partner and things like that. So if I tell you the output of the initial assessment, right? The assessment was that the situation was stalling, and it was kind of a deadlock situation because I could not seek relief from, say, the federal court, because the appropriate venue would be the state court, this higher state court, right, the appellate court. And so that was one of the roadblocks, right? The second thing was that from a procedural point of view, the appellate court was within the right to not respond. Like they're not obligated to respond within a certain time frame. Like they set their own time frame, right? So it was kind of a situation in which I was the thing was dead in the water, right? And not dead in the water, but it was dying fast, right? It was drowning. Right? But remember, I ingested all the conversations, right, that I had with my former partner in the car and in the house, right? Like all these conversations. And here's where something really marvelous happened. When I see these things happening, it I don't know, it's amazing, right? It's amazing to see something you create produce this kind of insights, right? If I can describe the feeling, right? It's like when I see my son is 4 years old, right? He just turned 4. And he's starting to read words by himself. Nobody has really taught him, like, how to read, but he's kind of doing it, right? And when I see that, it amazes me, right? Like how this thing that I created, my son, right, is able to, do intelligent things, right? And this is exactly the same, right? When I see this, a machine doing this, it's the same feeling, right? Is that feeling of seeing, witnessing really, right? Your creation doing something that, that you couldn't, I couldn't do it myself in this case of the legal vaccine, right? Anyhow, the vaccine flags a set of conversations about tires with my former partner, and flags that the child might be in danger. And also flags, it's a series, it's like a waterfall of flags, right? It flags the conversations about tires. It flags that the child might be in danger. It flags the conversations about, she made some statements in those transcripts that I have about spending more than $60,000 in legal fees, to declare me crazy in court. Basically, it's not a divorce even. It's just for temporary orders to declare me crazy, right? It flags that, and it makes the conclusion that a person that spends $60,000 in legal fees, and also in some conversations she said that she only had $9,000 in her bank account and that she was paying for the legal fees with credit cards, so she was getting into debt, right, to pay for the legal fees to call me crazy. And she engaged into a 24-month payment plan designed by the Adams law firm and Morgan Hypner to keep her on this, legal situation for years, I guess, because she doesn't supposedly, right, doesn't have the means to pay for it. So they created this payment plan, quote unquote, right? And so she made all those comments, right? So the pipeline, the legal vaccine, flagged all these things in chain, the conversation about the tires, the child potentially being in danger, my former partner declaring that she only has $9,000, right? It flagged the payment plan and the $60,000, the credit card debt that she's incurring to do this, right? And then it drives the conclusion that her mental state and abilities could be challenged in court, because a person that does not prioritize changing the tires of the car where they're transporting the child over spending $60,000 in legal fees and getting into debt with credit cards to do that, and with the lawyers on a payment plan, right? Like if it was a layaway program, is not a person that can be entrusted to make sound decisions for the child. Right? All this was derived by the video is getting, sorry, let me do something here, 1 second. Okay, I think, yeah, the computer was slowing down too much. 1 second. Okay, so yeah, so it drives this conclusion, right? And this is the important part. It's not, and like in this, I have to make a comment, right? Like this is one of the things that, so in the past, right? I've heard about people talking about the moral implications of using software to drive conclusions and to make decisions, and there's moral implications on that, like how there's a line, right? And then, when I hear those conversations, they always seem to me theoretical. Like they, I could, but seeing this, I really got a good sense of what those people mean when they say those things, right? Because I mean, what I'm trying to say, right? This legal vaccine, as if it was a lawyer, it's a super aggressive lawyer, like this argument, to make this argument in court, right? I really thought about it long and hard. Like it wasn't an easy choice. It wasn't an easy decision for me to make this argument, right? Because this is the mother of the child that I'm talking about, right? But let me tell you the entire reasoning of the thing so you can see, right? So the idea is that I mean the idea, right, of this reasoning is really of in the legal vaccine, right? The reasoning, the line of reasoning was, the goal wasn't to call her crazy, right? That wasn't the goal, but it was a necessary step to achieve the goal. The real goal was to unlock the situation with the appellate court. Why? Well, because if she is unfit, right, to be a parent, and the lower court is naming her sole supervisor and sole conservator of the child, right, and supervisor of the supervised visit, and having full powers because they stripped my parental power, so she can make all the decisions now, and she's unfit, the child is in danger. And if she's transporting the child with these tires and she's not prioritizing that over paying Morgan Heipner, tens of thousands of dollars and getting into debt for harassing me with the court, she's putting the life of the child in danger. And the appellate court has to act. Like not acting immediately, keep waiting, right? What they were doing, right? Not responding to the motions would be a grossly negligent act, right? Because we're talking about the life of a child, right? An innocent child that has done nothing to any of these people, right? So the legal vaccine then, through this line of thinking, recommends obtaining photographic evidence and an expert opinion, right, about the tires, to file it with the appellate court. So when I see the output, right, I really, well, this is I mean, let me translate this to you. In what this means is, well, take pictures of the tires, take the car to a tire shop and ask an expert, a tire person, right, somebody who works with tires all day, if these tires are good, and record that conversation. That's exactly what I did, right? I told her, let's go find an estimate and see if these tires are good or not, right? I didn't trick her. I told her exactly what we were going to do. And we went, look at the tires, and in fact, the attendant said, not the attendant, the tire expert said, these tires are gone. I'm quoting him, and he said, these tires are dangerous to drive with. You need to replace them immediately. And he gave us an estimate for almost $3,000 to $2,959, if I recall correctly. Because these are high-end tires. Like this car the car she's driving is a $70,000 car. And those tires, each tire is like $700, right? Each tire, plus labor, plus balancing, plus. So I got the photographic evidence and the report from the expert, the tire expert, exactly as the legal vaccine recommended. And I created, using the legal vaccine, a temporary restraining order, a motion for a temporary restraining order based on that the child is in danger. And I filed it with the appellate court. This was on the 13th, so that was yesterday at 11 p.m. Okay. So this morning at 7:40 a.m., only 8 hours after I filed the temporary restraining order, I get a notice from the appellate court. They finally replied. Only 8 hours after I filed that, right? The response was they were denying my mandamus, my petition for mandamus, based on that it's a moot point. But and then I run this, because I'm not a lawyer, right? I run this through the legal vaccine, and it tells me, looking at similar opinions, right? This is called an opinion, what they admitted. And the legal vaccine, generates at the output, and if I paraphrase it, it means, this is a kind of a standard language, and this is a standardized form. It's not getting into the substantive matter. It's just a page with one paragraph that says that it's being denied because it's a moot point. And the legal vaccines, if I paraphrase it, it says basically, this is a standard language, a standard form. That means that what you're asking is not possible because what you were asking to prevent, or the precondition, is already met. And then I go to the 387 court docket, and I see that the judge that on the 10th, Judge Oscar Telfair, that on the 10th said that we would meet on the 16th in person for another hearing, so I could contest the fraudulent orders of Bergenheimner. The docket says that he signed the orders on the 10th, on the very same day that he said that I would be heard on the 16th. The orders are signed. So the appellate court looks at the docket, right, and sees that the orders are signed, and say, well, you were asking us to ask the judge to sign the orders, and the orders are already signed. So it's moot, right? But the dismissal is really a procedural dismissal, right? They didn't address any of the allegations of the due process, anything, right? It's like they didn't even look. It looks like, if you read that, the logical conclusion is that they didn't even read the petition, right? Because it was a moot point. It could even be that this was done by the clerk, right? Like the judge may not, I don't know. Like, I don't know, Now, I have to say, in that document, the names of the justices is present, right? And it says that 3 justices made this decision. So I imagine they read the mandamus, right? Because they have the petition, because they have to make the conclusion that it's a moot point, right? But the interesting part is that the judge of the 387 court signed the orders on the same day. You look at the docket, and I saved this. I have this printed in a PDF document, and I have it, right? So even if it's changed, I already have it. Saying that the orders were entered on the 10th, although he said on the record that we would meet on the 16th, right? But you see, it gave, so the fact that the orders were entered on the 10th, signed, although I have to say, I have not received notice of any signed orders. And I asked the petitioner today at 4 p.m. if she had received anything, and she said no, that she thinks that the hearing is on Thursday, right? The hearing that the judge has scheduled on Friday. She also thinks that it's on Thursday. And from my point of view, I also think it's on Thursday because I haven't received any notice of any signed orders. So, they dismissed the mandamus based on that the orders were signed. But that is a win for me, right? That's exactly what I needed, because I want the orders to be signed. That was the whole thing that I was asking for, right? Because once the orders are signed, then Morgan Heibner is committed to her position, right? That she is committing to the fraud, right? Like, because the orders are now signed, right? I mean, it's like perfecting the crime, right? That's exactly what I need. And also, importantly, it unlocks me because now it's clear that I cannot seek relief even at the appellate court, right? I've already tried, right? And it wasn't possible, right? So that opens the door for me to go to the federal court, which is what I did today. But before I get into that, I want to highlight, right, the brilliance of this system. It found the path to unlock the situation. And the path was filing this temporary restraining order, right, highlighting the danger this child is in, because this is a motion that the appellate court cannot ignore, cannot delay, right? Because it would be a gross indifference, or I don't know what it would be called, right? Like ignoring this because of the seriousness of the allegation and the danger to a minor child, 4 years old, is not something that they can address in 60 days, right? Because the child could be harmed by then. So it was a brilliant move, right? And finding that the tires, I mean, I would have not found that, right? Now, to show, right? And I did this on purpose, right? So I had this prediction yesterday on the 13th, right? And I had this path drawn by the legal vaccine, by this distributed software system that I built. I had this already designed on the 13th, predicting what was likely to happen, right? That they would rule either on the motion for the temporary restraining order, denying it or approving it, right? Or procedurally denying the entire case, right? Because when they deny the case in that language, it says, and this is important and crucial, it says, so we are denying, this writ of mandamus, and all pending motions are now mute, right? Meaning that they are not going to even look at the temporary restraining order motion. Like, that's what it really means. So that clears from liability, right? Because they didn't look at it because the case was closed before they could get to that, right? So they closed it procedurally, right? Not based on the substantive matter of the issue. But again, as I said, that's a huge win, right? That is a huge win. That's exactly what I needed, right? And so what I was going to say is that I had this, let's call it potential sequence of events, right, that could unfold the next day. So I had this on the 13th. And because I had this, I used the vaccine to draft a federal complaint, right? On the 13th, I had the complaint already ready yesterday for something that was going to happen today, right? Or tomorrow, right? Before the hearing. They had to do this before the hearing because they could not get to a point where I go to the hearing and there's this pending thing, right? Alleging imminent danger to the child. So I had the motion already prepared. I mean, I had the claim for the federal court because now if this happens, right, if they deny the TRO or the entire case at the appellate level, it unlocks the federal court. So I already had the federal claim prepared yesterday, even before they actually took action this morning, right? So when I see that they take action this morning and they deny the thing, I go to the docket, I see what they did, right? That the order was entered on the 10th. I immediately go to the federal court. And I think I'm saying this because I think it has value to show the timeline and how short it was. Why? Because if you read that complaint, I'm saying this to anybody that would see this in the future, right? Including authorities. If you read that complaint in the federal court filed today, October 14th, 2025, if you see the complexity of that complaint, and I'm not a lawyer, right? If I was a lawyer, maybe, they could do that in a day. I don't know, right? But I could not have possibly done that in 4 hours, right? Because I got the notice at 7:40 a.m. And by 1 p.m., that was already filed in the federal court. So in a space of 4 hours, I went to the federal court, which is an hour driving from my home, and filed it. And not only that, in the morning, and you can see this, I imagine, right? Authorities eventually, right? When they see this, they will look at the satellites, right? To see all the cars and everything, right? You can look at the satellite and you can see my house at Lake Point Estates, and you can see that I even went running in the morning. I ran for an hour and 15 minutes in the backyard of my house at Lake Point Estates in the morning before going to the federal court. So in 4 hours, I went to Lake Point Estate, ran for an hour, 15 minutes, and then went to the court and filed it in 4 hours, right? So this tells you that I had this already prepared yesterday before it even happened, right? Which tells you that the technology that I developed works. Because how could I have not only foreseen what they were going to do, but also prepared the federal filing in 4 hours, right? Okay, so that's the sequence, right? Now I have to say, right, that filing of those orders on the 10th, I don't know. It looks to me, it looks, and again, like here, like I'm not gonna make any. But let me put it this way, right? If I was them, I would. If I was the judge, I would not sign the orders on the 10th, right? Because it's a huge liability to me. If I was the judge, right? If I was the judge in his situation, I would not sign the orders on the 10th because I already said on the record that we're going to meet on the 16th. I mean, all the liability is going to fall on me. I would have to be crazy to do that, right? So I have to ask my question, right? If I was the network, how would I do this, right? Reverse engineering, right? How would I pull this off? I don't know. I don't know if this is what they did, right? I don't know if they, because remember, I haven't received the notice, and my former partner tells me that she doesn't know anything, right? Which either means that Morgan Heibner is withholding the notice, the order, the actual orders, right? Even from her own client, keeping her client on the dark about such an important matter that she's charged $60,000 for, or 45,000, I don't know, right? How much, but tens of thousands of dollars for. And she's not going to inform the client that she won what she wanted, which is to get those order signs in the way that Morgan Heibner drafted them. I mean, it's logical, right? She has to tell her immediately, right? I mean, for such a high price tag, she has to tell her the minute this happens, and she hasn't told her anything. And this was on the 10th. In the docket, it says that it was on the 10th, and today is the 14th. So 4 days have passed, and Morgan Heibner hasn't told her own client about the orders being signed. What is this? So I have to ask myself the question, how would I do it, right? If I don't want the judge to, if I was the network, right? I would do it with the clerk, right? I would create a clerical error that results in an entry, a bogus entries for a temporary orders that the appellate court can then see and justify their decision, right? In this way, if this comes to head, the foul person is the clerk, right? Oh, the clerk made a mistake, poor clerk. We're gonna fire the clerk, right? But none of the judges are liable or responsible anyway, because if you look at the appellate court, they were acting on what they saw on the docket. I mean, how can they be at fault for doing their job, right? They have to check the docket before processing the mandamus. And if you look at the judge, he didn't really sign the orders. It was a clerical mistake, right? And this would explain, how I always say, when I form an hypothesis, when I reverse engineer what I do, I see if the hypothesis checks all the boxes, right? This hypothesis checks all the boxes. It protects everybody, including Morgan Heibner, and the other important property, yeah, so it protects everybody, right? And it also explains, I mean, this hypothesis would also explain why is that I haven't gotten a notice with the orders signed with the signature of the judge, and my former partner hasn't gotten the order either, right? Because maybe the orders don't even exist, right? But that entry being on the docket makes it so that the appellate court can make that ruling, right? And dismiss the case on a procedural basis. But it doesn't matter, right? Because from my point of view, the objective is achieved, is that it's unlocked the door to the federal court, right? Now, because otherwise, if I go to the federal court before this, in the federal court, the judge can say, like, go seek relief at the appellate court, right? Like, there's a federal court that's a state. Sorry, go seek relief at the state court, because we have a state court system, and they are the ones that should handle this. But if they are already denied any possibility to protect the child of this imminent danger, then it unlocks the door, right, of the federal court. It makes necessary the intervention of the federal government. That's my argument, right? So it was a tremendous monumental win, really. I mean, they handed it to me, right? Even if it's procedural, like I don't know exactly what was the mechanism at this point, right? I have to wait to see if they give me the order or not, sign, right? Or if it was the clerk, right, that made the quote unquote mistake. But it opens all sorts of possibilities in the future, right? So it's a super interesting development. But the real, I think the interesting thing to me, at least, because I'm an engineer, right? Like I look at this from the eyes of an engineer, right? Is I don't know how to put it into words, right? But I would say the empowerment, right, of a human being through the means of technology, right? It's what's it is what amazes me to see, right? It's incredible. But as I was saying, also, right, like when this happened, right, when I saw what the system was highlighting about, the conversation about tires having this chain of implications that would result ultimately into this scenario, that is a win for me. It made me ask myself the question of, how to draw that line, right? Because I can see that this legal vaccine could be a very aggressive lawyer. It's very aggressive. I mean, but of course, when I saw the reasoning, I don't want to say that the goal justified the means, right? Because I do not think that way. I think there should always be a line. And I try to live by that. But, when I saw the line of reasoning, because, like the other option, right? I mean, I see the child is in danger. I can pay for the tires, right? I could, give the tires to her, which would be detrimental to me, because it's basically I'm going to give her $3,000 that she will use to harass me with the courts, right? She's going to have more resources to harass me with legal action, right? As she's been doing for 6 months. But the child's safety comes first, right? But if I solve the problem and buy the new tires, then I would still be waiting for the appellate court, right? So I don't know. It's one of those things where the application of technology also has, I don't know how to articulate it, really. I think I have to think more about this, right? It's one of those things that is not fully formed in my head, and I can't verbalize it correctly. But if I made an attempt right now, it would be something like, the machines are too pragmatic, right? And they don't have the moral fiber that we human beings have. And therefore, they have no filter, right? And they will do everything necessary to achieve the goal of the scenario. And that could also be bad, right? In some cases, right? I guess what I'm trying to say is that collaboration between human and machine needs the moral fiber of the human, right? It's important that the human working with, I'm not going to say even operating the machine, because it's more like working with the machine. It's important that the human that is working with the machine has a strong moral fiber, right? Because otherwise, this would lead to chaos, right? It's too much power to give to an individual with no morals, I guess it's another way to put it, right? Imagine what you could do, right? Imagine what they could do if they had the legal vaccine. What they could do to me, for example, right? They could put me in prison with this, right? They could find ways to imprison me using the legal vaccine. So it could be a dangerous weapon, is what I'm trying to say. Right? In this case, it's saving me and saving the child, but it could also be a weapon, right? And I'm conscious of that. Okay. So that's the situation, right? So now there is another case, another second federal case, right? And in this case, the main defendant, the first defendant in the list of defendants is Morgan Heibner, because she fabricated the orders to the judge. She changed the orders to the judge, and she's on the record saying that she modified the draft. It's crazy, right? Like, how incompetent can you be? She's saying on the record that she is able to modify the draft that the judge is going to sign, depending on what my needs, on what I say. Right? So she's admitting that if I say something, it could cause her to modify the proposed orders that the judge is going to sign. Right? And not only that, by extension, she is also saying that she did modify the document that she sent on the second, and that the notice was improper. Right? So she's admitting that she's violating the procedural rules, and the judge is not ruling on the objection. Like, she created like 10 different ways for this to be, disarmed in just one sentence, right? But anyhow, she is now the respondent number one in that federal case, right? Which was unlocked by the swift action of the appellate court today. It wouldn't have been possible if the appellate court hadn't taken that step. And this is an interesting point as well, because it talks about this situation, right? This sequence talks about the perception of legal liability. The appellate court took action 8 hours swiftly, right? It was super fast. I mean, these people, they were working since 6 a.m. I don't know what time they opened, right? But how did they produce this so fast, right? But it was only after that motion alleging imminent danger to the child, with pictures of the tires. You can see in the pictures if you download that motion, and it's I already put it in the folder, right? In the Google Drive of the channel. There's pictures of the tires, and you can see the metallic mesh. You know how tires, they have the threads made of rubber, right? And underneath, there's a metallic mesh that you should never see, right? If you see the metallic mesh, it's because the tire is so worn down that it's about to explode, basically. Well, 2 or 3 of the tires, I can't recall, I have to look at the pictures, but multiple of the tires had the metallic grid very visible yesterday on the 13th, right? When we took it to the tire shop, and the expert said, these tires are gone, right? So if there is photographic evidence, the opinion of an expert, and an estimate from that expert of how much the danger is obvious, imminent, and undeniable, right? So they had to take action, right? But these only happen because then if they don't take action, then there's liability, right? People could say, this is negligence, right? Really. But they did take action, so kudos on that. But what's interesting, right, is a observation of the perception of personal liability, right, or individual liability. Right? And this is the reason why I think the judge maybe didn't really sign the orders, right? It was a quote-unquote clerical mistake, of course. That would ripple down into this dismissal, which, by the way, would be the perfect solution, because the other issue that was raised was how these other lawyers came up, right? So the real party in interest, my former partner, retained this expensive multi-city law firm to represent her when she's saying that she has $9,000 in her bank account, and she's already in debt with credit cards and on a payment plan with Morgan Heibner, and she's retaining another lawyer, right? So this was going to raise hundreds of questions about who's paying for all this. So the solution is to dismiss it procedurally, so these other lawyers don't even have to reply, because if they reply, it's going to raise eyebrows, right? Like, but because they didn't reply, then they didn't charge anything, and nobody can question where the money came from, right? So that's why it's important to dismiss it procedurally, not on the substantive matter of the issue, because that would require a reply from the lawyers, right? Now, still, right? Now, and this is important, the legal vaccine also in this system that I have flag another super interesting thing. By questioning the petitioner mental ability and asking for a psychiatric evaluation on the 387th, she has to reply to that motion. And Morgan Heibner cannot or should not help her reply to that motion. Why? Because she put her on a payment plan of 24 months, right? And is charging tens of thousands of dollars in fees with somebody whose mental capacity to somebody whose mental capacity might be challenged. She cannot possibly help make the argument in that court that her capacity should not be challenged, because that would directly help her collect $45,000. I don't know how much, right, in fees. According to the petitioner, it's more than $40,000, only with Morgan Heibner. So she cannot, Morgan Heibner cannot possibly help her dismantle or disarm that motion that I filed, because she would be helping herself, right, to keep her payment plan going for 24 months. So now the same question is going to arise on the 387, right? When she retains another lawyer, right, that is also going to be, top shelf, top tier. The same question is going to arise: who is paying for this lawyer? And now she has to pay for the tires, right? And she had $9,000. We can do the math, right? So how is that going to be justified? I don't know, right? But I think it's also a moot point, because now this is on the federal court, right? And the federal court is going to look at all of this, right? And the FBI can look at what happens in the federal court, right? The filings, the documents, the allegations, everything, right? So I think, they handed me the keys with this. I'm trying to see it in a different way to see, where is the catch, and I can't find it. So I don't think there is a catch. But anyhow, I'll run the legal vaccine, of course, to see, if there's anything. There's two things that will come up, right? One is, my former partner said something about October 1st, and she said the judge said something that I had to do by October 1st, and she didn't want to tell me what it is, right? And it's funny, because Morgan Heibner is not sending me the order. So how am I supposed to know what I'm supposed to do by October 1st if they haven't sent me the order, and today is October 14th, right? I'm not a mind reader. I don't know. So, but they're gonna make up something, right? They're going to attack me with something, and this is important, right? So now I'm going to talk a little bit of things that are not really legal story, but I think it's important because it's in technology. I'm reusing the same technology. So I haven't said this before, but I used the legal vaccine and I kind of merged it. I created kind of a Frankenstein pipeline, right, with the KOL vaccine and the legal vaccine. That's why in the last session I said the KOL vaccine. I was referring to this Frankenstein. I don't have a name for it, but it's a combination of the two. And it's a pipeline to defeat manipulation, psychological manipulation. Okay, I'm not going to give away the technology, as I always do. I just give vague ideas for obvious reasons. But eventually I will give this to the authorities, right? That's my intention and that's my plan. But it's a pipeline to defeat psychological manipulation. Okay, and the way it works, it flags, because I have the transcripts of when I'm in my house or outside on the streets in public places, and my phone is I have my phone with me and it's recording. I have the transcripts and I process them through this pipeline, right? And it flags what it looks for. I'm going to just give you an idea, right? It looks for conversations that have not happened ever and come up repeatedly in a short period of time. The idea or the design here is to find, remember when I said in some of the demos before, like one example, right, to give an example, when they steered me towards getting the the procedure with Dr. Vitenas, right? That multiple of my friends and people from the network started telling me at the same time, right, that maybe I should invest a little bit of on myself and to refresh my image and to make me think that I needed this, right? This is a good example, right? During all my life, if I had a transcript of all my conversations with these people through all my life, this topic of plastic surgery had never come up, right? And in this short period of time of 2 months, it came up repeatedly, right? So that conversation would be, that topic would be flagged by this pipeline, right? Of course, I didn't have the transcript back then because I didn't know, right, that all these people were agents. But now that I know, I have the transcripts, right? I'm keeping the transcripts now. So there were a couple of conversations that were flagged, right, by this anti-manipulation pipeline. One is something related. So this, I'm going to tell you the sequence, right? I don't know exactly what is the play yet. I have to run this through the legal vaccine standalone to see what could come out of this, right? But one is something related. This is the sequence. I'm going to tell you the sequence. Maybe if my favorite informant, if you have an idea or know what this is about, please tell me, okay? Because that way I can defeat it. My favorite informant is the Venezuelan army informant, right? That is trying to do his, coup d'etat. So I want to tell you the sequence, right? So these are the conversations that are flagged. The sequence is always the same. My former partner starts the conversation by saying that she has spent more than $60,000 in legal fees. And then she starts crying immediately, right? And she says that all the money for Sebastian College is gone, right? And then in all these conversations, I respond in the same way. If you end up getting nothing from the divorce, which I think is going to be the case, right? Because at the end, you can't profit from this, right? But what I say to her is that if you end getting nothing from the divorce, I will pay for Sebastian College, right? And then after I say that, she changes. She stops crying, and then in a few minutes, she starts telling jokes and laughing, right? It's an immediate switch. So it's something, right? They want me to record me saying something that I will pay her for something, right? I imagine it's some sort of civil claim that they're going to make later, right? Or their plan, right? They think that they're not going to be criminal charges, and then they will make a civil claim, right? To harass me further with the courts, but in another court, right? With another cause, another thing. Has to be something like that, but I don't know exactly what is the play, right? Because what I'm saying is conditional, right? Like if you don't get anything from the divorce, I'll pay for the child, which I'll pay for the child college anyways, right? Like I've said this multiple times. I see him as my child, right? But this is interesting. This anti-manipulation pipeline also flagged the following, because I put into the transcripts of everything, including these demos, right? So this is the sequence. In one of the demos, I can't recall the day, I have to look it up in the system, but there was a demo in which I said this phrase, or something like this. Don't quote me, right? But it was something like this. I said, I was talking about Max Terasuk, the guy from Calgary, right? That was trying to steal the technology using legal means, of course, right? Because that's what they do, right? So I was talking about him, and I made this comment. I said, I retained this lawyer that is a Texas lawyer, of course, that was a judge, of course, right? He's from Austin or from Dallas. I can't recall. I have to look it up. His last name is, I can't recall. I have to look it up in the system. But he's a judge, right? It's documented in the website and in the book. And I made this comment. I said, well, this guy, he was an older guy. He was like 50 or 60 years old. He was a retired judge, pretty much like Perwin, I would say, right? The description would fit more or less that. And I said something in that demo. I said, this former judge offered me to act as if he was my inside counsel to deter Max they were working together, right? But that's what they made me believe. And he did it and charged only $100 per hour, right? And I immediately said yes, because I thought that it was a good way to deter Max. And I would not, at that point, I couldn't spend, I didn't want to, I could, right? I had the money, but I didn't want to spend, $30,000 paying a $500, $400 attorney to fight with Max. That's the phrase that I use, right? So the manipulation pipeline flags that Morgan Heibner, right, in one of the filings for attorney fees, she put in writing, right, that she's an attorney and that she charged $450 per hour and that her bills are more than $30,000. So she said, right, in that writing, the same things that I say that I could not do or that I didn't want to do to fight Max, right? So you see the manipulation here, right? So what they're doing, right, is putting this in this legal harassment action that they're doing with this lower court. What they're doing is using the exact same thing I didn't want, right? It's like, oh, this is what you fear. Okay, here it is, right? It's A/B testing. That's what it is, right? So I think it shows two things, right? One, that they're very aware of everything that I say in these videos, and they actively they're looking to see what they can use to harass me more, right? They think they can harass me, but I'm unharassable at this point because I'm using technology for this, right? It's silly, really. But that's what they're doing, right? And I think I say it's silly. We have a saying in Spanish. I don't know if I don't know, right? I don't know if in English there is an equivalent thing to this, but in Spanish, we have a saying that if I translate it verbatim, it would be something like, the fish dies because of the mouth, like it's a way of saying that, when you talk too much, the things you say come back and bite you, right? And this is a good example. So because they wanted to harass me with that thing that I said that would be negative to me, right? They put that in those documents of Morgan Heibner charging $450 per hour, and that the bills were more than $40,000 at this point. I don't know how much they put in there, right? But so tens of thousands of dollars in legal fees for the petitioner, because the reasoning is that the petitioner is saying that she has no money. So at the end, one way or another, I am the one who's going to pay for all that, right? That's what they want to make me believe. But I know that's not the case, because they cannot profit from a crime, right? They can't charge me for a crime they're committing against me and my son, right? And I know it's a crime, and I know I have the proof, and I know that they're going to go down. If it's not this month, it's going to be next month, but eventually they will go down, right? And when that happens, they're not going to be able to collect any of that money from me, right? So that doesn't scare me. But they think it scares me, right? So that's why they put it in the document. But now, and this is what is ironic, right? I don't know. It's ironic, really. It's laughable, right? Because they put all that. Now they can't explain how is that the petitioner is paying for all that, and that is going to bring the question up of who's paying for all that money, And those more sophisticated lawyers that are higher end than Morgan Heibner have to charge more than that. So how is she going to pay for that, right? So that attempt to harass me with that thing that I said, I mean, doing the same thing that I said that I didn't want to do, is the cause because of which now they can't protect any of them with lawyers, because they will not be able to explain how are the lawyers being paid, right? So it's one of those things, like the fish dies because of the mouth. There's no, I don't know. I imagine there must be an equivalent saying in English. I just don't know what it is exactly. But she put all that in writing, right? And I think she even said it on the record in one of the hearings, right? But it's in writing. It's in and when she was in the motion where she was asking for attorney's fees in that section, it's all written in there. And she talked about how she charges $450 per hour, and so far her bills are, $30,000, I don't know, like some number like that, right? So that's one example. And the other example of the manipulation they do with this is Sebastian. That thing that she says, that Sebastian is going to not be able to go to college. They're saying that because in one of these demos, very recently, I said that I didn't want to harm Sebastian, I said, I have this information in one of the demos. I said, I have this information, but I haven't acted on it for months because I don't want to harm the child. Because, this person I'm talking about is his dad, Andres Mendez or whatever his name is, right? Salvador Mendez, I don't know. And I said, I haven't talked about this because I don't want to harm him, right? So now my former partner is in all these occasions telling me that Sebastian is not going to be able to go to college because she's spending all the college money in legal fees to harass me, right? And I'm making it more difficult for her because I'm resisting the harassment by filing motions and going to other courts. So I'm making the harassment more expensive than it needs to be. It's basically the argument, right? So for Sebastian to go to college, the solution is that I let the harassment happen quickly, right? That way Sebastian can go to college. I mean, please. But you see the pattern, right? They're using the things that I say here to see what they can find to try to harass me. But that doesn't work because I know that after all this over, Sebastian is going to go to the best college possible, right? That money can buy because I will pay for it, right? With their own money. I'm going to get the money from there. I'm going to pay for his college, right? That's my plan. So, because now I'm suing Morgan Heibner personally, right? So when I get her in the federal court and I take her assets, with those assets, I'm going to pay for the kids' college. That's the plan. And you'll see this will happen. So, because now this is a personal lawsuit, right? And I invite you all to read. And I think I should give more information about this. The allegation is that Morgan Heibner conspired with a group of police officers from the Fort Bend Sheriff Office to deprive me from my constitutional rights. So I'm suing Morgan Heibner and the police officers that participated in their individual capacities, and the police officers also in their official capacities, and the Adams law firm, civilly, right, for damages. So when I get them, with that money is that I'm going to pay for the kid's college, and I'm going to make sure that he goes to the best possible college, the most expensive one, and I'll send you the pictures so you can see. Okay. So yeah, but the important thing, right, is that they see these videos and then they see what are the things that I say that worry me, right, or that would have worried me 3 years ago, and then they try to do them in court but the anti-manipulation pipeline flag that they always make this comment. My former partner makes these comments about the kid not being able to go to college because I'm making the harassment take longer, right? And after that, the sequence is that I always say that, don't worry, I'll pay for the college if you don't get anything from the divorce. Like that's what I say. Which, I know it's probably going to be the case, right? But as I said, regardless, I will pay for the college of the kid. Like, he's my son. Regardless of whatever happened, right? There is no need to even ask the question, right? But so they're planning something, right? Because they want to record me saying this thing. It's obvious to me that there's intentionality behind, and what I said in that car, it's always in the car. It's always inside the black Tesla. So I know that it's because it's being recorded, right? That's why they're doing it in the Tesla. And then they're recording it because they're planning to use it for another, I imagine, right? For another type of harassment. But I don't know exactly what it would be, right? But whatever it is, I will disarm it because this is a criminal enterprise and they are the ones committing crimes and they can't profit from the crimes. So that's that. So and I think with this thought, I'm going to close this session. The thought is that this anti-manipulation pipeline, if you think about it, right, what I'm doing, I guess I understood by having to develop all this, why was the need for them to develop Neon with Major Thakur? Because that's exactly what they're doing, right? They're turning interactions between humans via email, via in different. They transcribe the conversations, the phone conversations, right? Telephone conversations, and they put them. They index them into Neo, right? It's a powerful tool. Like, this is exactly what I'm doing, right? And it's not like I copied it from them. I never had access to. I want to say this disclaimer, right? I never had access to the Neon code because I was in a different team, and Major never gave me access. But from the things that Major told me, I can see the power, right, of ingesting all the interactions. So the goal, like the high level, this is not a technological secret. Like, it's just, and I imagine, like, the NSA must have something like this, right? Basically, the technique is turning human interactions into structured data, right? As much as a structure as you can possibly do it. Because with that, you can apply all sort of information retrieval techniques and tricks to derive insights, right? But the key is to have the data in a structured textual form. It has to be text, right? So you can derive insights. Because if you have video, right, you can put metadata in the video, but it's not, if you have the transcript of the video, then you can analyze the transcript and find entities, find relationships, find things, right? Mentions, annotations, annotate the entities, but it's necessary to transform it into text, right? So the thought is that process of turning human interactions into contextual structured data is, a super effective weapon, right? That can be used for good or for bad, of course. And in this case, I'm using it for good, right? So I imagine, right, that's how they do it as well. Like, I imagine, right, what they do is that they take these videos that I create, they transcribe them, and they put them into a system, right, to trying to find these things quickly, right? Things that they can use to, like, the thing with the college of the kid, or the, the lawyer fees, right, to try to harass me with that. I imagine it's something systematic because, I mean, they're doing this to me right now, but remember, they do this at planet scale, right? They do this to everybody. So the only way to scale this to a planet scale operation is to do it using software. So, that's why they have to have an automated way of finding quickly these things. Of course, after they find them, it's like the same thing I do with my pipeline, right? My pipeline gives me the flags and the debug output, and then I say, okay, I understand what this means, right? And then I transform that insight into an actionable item. I imagine it's the same, right? They turn the information, the recordings, the legal recordings they do with the cars, and all those things, the box, and the things that people post online, turn them into structured textual data, text data. So basically, they transform into text, right? And then they annotate the text, and then they ingest it into a pipeline and find things, and then they flag them. And once they flag them, a human makes a decision. Okay, this is something we can act on, right? I imagine it's something like that. But super interesting, the developments of the legal vaccine. So now the federal court is unlocked. Morgan Heitner is in there. In fact, in this video, let me give you a tool, something that you can actually look at, right? So I'm going to share my screen. 1 second, okay? Okay, so if you go to the YouTube channel, right, which is Rapid Fire Tips. Let me see. It's refusing to share for some reason. Let me see if I open a different browser. 1 second, please. Bear with me for just 1 second. Okay, this one worked. Okay. Okay. So I want to go to the YouTube channel. Okay, and if you click on here on more, right on the header of the channel, there is a link that says more. So the address is YouTube at, so YouTube is youtube.com/@ rapid fire tips all together, and that's the URL. Sorry, my computer is a bit slow, but let me try to show you how to get there. Okay. Yeah, so there is, I think it's this one. Let me see if it's this one that says, so when you click on more, this small window will open, right? And there's a few links in there, and one says channel archive. I think that's the one. So if you click on that, it's basically a folder in a Google Drive. Let me try to open it. Let me just double check that we're looking at the same. Yes. Okay. So in that folder, there is a subfolder that is this one that is called legal fronts. Okay. So in that folder, you have, for now, you have the appellate court, first district, which is where the case was routed after really submitted to the 14th, what I described before. And then there is the federal court, right, subfolder. So if you click on the federal court, you will see two dockets. So two subfolders, one for each docket. One is the case in which defendants are Elon Musk, Wilmer Ruperti, and other people. And let me show you. Sorry, the computer is super slow because let me close this other tab. Okay. No, it's too slow. 1 second. Let me see what else can I close here. Let me disconnect the say. Okay. Okay, so I disconnected the camera for a second. I think it's the camera that it's misbehaving. So I'm gonna do this part without the camera. Okay. So you have two folders. One is the one for Elon Musk and the other people, which is this one. And this is interesting. This is the notice of cancellation that I received the other day, and you can see here that the conference that was scheduled for the 8th was canceled on the 6th. In the demo before, I said 5 days before. It was 2 days before that it was canceled, and the clerk that canceled it was Nathan Ochsner, the clerk. But the one we're talking about today is this one. The case number is 4:CV-CV-04890. And the caption is Aguiar Marcano v. Rivera Hatner. That's Morgan Taylor Rivera Hatner. Right? And the random judge selection, which happened, this is important, right? In case then the judge changes. The random judge selection that happened the moment I filed, they picked the judge, David Hittner, with 2 T's. And in this document that says one, I think it's this one, that says one.pdf. See? Yes, that's the actual complaint. Okay. Let me see if I can open it to show you quickly. Okay. So you can see here that in this blue text, right, that it's filed. And you can see the defendants, right? And you know, the reason for the lawsuit is violation of civil rights under the color of the law, right? Because Morgan Heibner, as alleged, conspired with a series of police officers to kidnap the child. So, you know, it's all in here. The entire sequence of events, right? How it happened. You know, the instance where she sent the process server to my home, the fraud upon the court, how she weaponized the mediation process, right? All of that is in here. So, you know, it's going to be interesting. But I think what I wanted to tell you is that in this folder you will find the documents for the 2 federal cases, and for the appellate court, this is the denial that I received today, right? And you can see what I was telling you, that it's just one paragraph. And you know, it's a procedural dismissal without addressing the substantive issues, like the violation of the process, the danger to the child, anything. Nothing was addressed, right? It was procedurally dismissed. So that document is also in there. And you can see the names of the justices, right? So it says the panel consists of Justice Adams and Justices Morgan and Cupil, right? So those are the 3 justices that issued this opinion, memorandum opinion. So I'm going to stop the sharing at this point. And I'm going to reconnect the camera. Okay. Yes. So I think for this session, you know, if I was to think of a conclusion to give you, it would be that, right? It would be the use of technology to defeat this, right? Because it's there's no other way. But the interesting thing to me is, so there's a few interesting things, right? So one is, as I said before, how, you know, sometimes people will prioritize mitigating personal liability instead of the collective, right? And I think I said this in another level, right? This is why their system is not sustainable, right? Because people, when they see exposure, they go on the other direction. The other thing that is interesting is that they don't have a similar technology to what I have with the legal vaccine, because otherwise they would have seen that it would open the door to the federal court, and they wouldn't have done that, right? And the other thing that I saw was that I am able to defeat at this point completely their decryption and interception capabilities. The reason why I say that is because today they had no idea that I had this prepared, right? And I know they had no idea because of the type of surveillance they were employing in the morning when I went to Lake Point Estates. it was a very overt surveillance. Like all the agents had the windows rolled down, and they were like basically walking with their faces visible in front of the cameras. It was a very overt type of surveillance. Let me see if I can fix this. It's yeah, the video is getting. 1 second, please. I'm gonna stop it and start it again. Yeah, sorry, my computer is not. It's not collaborating today. Yeah, so I'll finish the session without the camera because it's not working. So what I was saying is that yeah, the type of surveillance they were using in the morning was very overt, and they had people stationed at the places where I was likely to go. Like at Lake Point State, they had a team stationed there just in case I went there, right? So that tells me that they weren't sure where I was going to go. If they knew that I was going to file this document with the court, they wouldn't have that team of people there, right? And they would not have employed the techniques of surveillance that they employ today. So that tells me that they didn't know that this was coming, and that tells me that I defeated their interception and decryption completely. And that on itself tells me that the main vector of attack was the Chrome browser, because that's the thing that I stopped using, right? The Chrome browser. So there is something in the Chrome browser, and I'm sorry, I said I would not do this of getting into technical details, but it's an immediate conclusion of these legal developments, right? There is something in the Chrome browser, in the Chromium, really, which is the engine. Chromium is like the open source version of Chrome, right? So Google has Chrome, which is their product, but they also have open source, the engine, like the source code, right? Basically, it's a version of Chrome that has proprietary things removed, right, from the browser, and they open source it. And I say this because like 2 months ago, I stopped using Google Chrome mostly for most of the things, and I started using Chromium, right? And they still, when I use Chromium, they start bringing the cats up from outside. When I say cats, I mean the agents. I call them cats because that's the way they call it. It's an important marker, right? So they're cats. In their world, their jargon, they probably use cats, right? And I'm not gonna get into it. That's how I know that, but so the cats, when I use Chromium, the cats immediately come out of the houses, right? So I stop using Chromium, and I can see the difference, right? It takes them longer. So if I don't use Chromium, the method of detection is a radio frequency probe that they have somewhere, right? That tells them the antenna is active. But the delay, right, between me turning on the antenna and them coming out is longer if I don't use Chromium or Chrome than if I use Chromium or Chrome. And if I use Chromium or Chrome, there is a slight difference in the timing, but it's negligible. It's very small. So, I would think that Google Chrome is more compromised than Chromium, but Chromium is compromised. And this other method that I'm using, that I'm not going to, of course, say what is what defeats them, right? So the fact that they didn't see the filing in the federal court today coming tells me that I'm successfully defeating their encryption and interception. Even them having all the houses surrounding me, they can't intercept the traffic at this point. So it took me 18 years to figure it out, but I think I can claim victory on that at this point. Anyhow, I think this is a good point to stop this this session. So thank you so much for your time, and I'll see you in the next one. Thank you.